What does it come to your mind when you think about the jury system? According to the legal dictionary, a jury consists of a group of citizens randomly selected from a general population and brought together to assist justice by deciding the facts of the cases, constitutes the truth given different evidence by opposing parties. In relation to the Bureau of Justice Statistics, each year, the name of around 200,000 potential jurors are randomly selected from the NSW electoral roll and included on the jury roll. Approximately 150,000 people on the roll are sent a jury summons notice at some point of the year. This notice requires them to come to the court, where they may be selected as a juror for a specific trial. Out of this, only 900,000 people a year are selected to serve on jury panels for specific trials. As stated by Richard Bogle in the journal The International Development of the Jury, The Role of the British Empire, the first evidence of the jury system was in Aristotle's description of the eternal law written around 350 BCE. Later, the Norwegian system of things, of course, influenced the English and Scottish law. When King Henry II ascended to the English throne, he reformed the Norman government by weakening the feudal ties of powerful English and Norman barons. He replaced local laws with a system of common law, which includes trial by jury. The modern jury system was first developed in the English common law, and it gradually spread to the other Western European countries throughout the 18th and 19th centuries, such as England, United States, and Australia. Originally, jury was a group of local men who knows the fact of the cases and provides a verdict based on their own knowledge. Nowadays, a jury system consists of 12 independent people with no previous knowledge of the case of the parties, deciding on the basis of evidence presented in court. The judge will assist them with any point of the law, and the lawyer will be aiming to make their case as clear as possible in order for the jury to have a better understanding of the cases. Lawrence Friedman, in the article Civil Bench and Jury Trials in States Courts, provided a sharper mental image of the jury system. The jury sits in its box. The judge sits on his or her high bench. The witnesses raise their right hand and swear. The lawyers and the defendant sit at tables facing the judge. The trial itself is long, tense, and full of excitement. Then, the judge instructs the jury. The jury retires to a locked room, and the spine-tingling period of waiting begins. Finally, the door opens, a hush comes over the crowd in the courtroom, and the jury comes in and announces its verdict. As referring to the article, A Knife in the Heart for Trial by Jury, in 1956, Lord Kelvin wrote that trial by jury is more than an instrument of justice and more than a will of constitution. It is a lamp that shows that freedom lies. It cannot be denied that jury plays a vital role in the criminal justice system in England and Wales and many other countries in the world. In criminal trials, a jury hears evidence, applies the law as directed by the judge, and decides if a person is guilty or not guilty of a crime. If it is a criminal case and the jury has given a verdict of guilty, then the judge will decide appropriate sentence. On the other hand, Tom Brooks, in the journal The Right to Trial by Jury, stated that juries occasionally sit in trivial trials involving cases of defamation, false imprisonment, fraud, and malicious prosecution. In such cases, the trial judge will outline the issues and the jury determines the facts, that is, whether or not the defendant is liable, and decides on the amount of damage to be awarded. In relation to the journal Jury Service, the verdict and exploratory study of public attitudes to jury service, as stated by Section 1 of Juries Act 1974, to be legally qualified for jury service, an individual must register as an elector. Also, he or she must be aged between 18 and 75. Last but not least, the individual must be ordinarily resident in the UK for 5 years from the age of 13. Before April 2004, there were 4 groups of people categorized as being ineligible for jury service. Group A, the judiciary. Group B, other people concerned with the administration of justice, such as police. Group C, the clergy. And Group D, mentally disordered people defined under the Section 7 of Mental Health Act 1983. After April 2004, Section 321 of the Criminal Justice Act 2003 abolished Group A, B, and C. only Group D remains ineligible. Valerie Hans, in the journal The 21st Century Juror, The Worst of Time or the Best of Time, stated that centuries ago, trial by jury was the primary method of resolving criminal charges, but it has been a downward slide for some time, with judges and especially prosecutors taking over more and more of the jury function. The suspicion of the public on trial by jury led to the emergence of several questions on the fairness of the jury decision-making process in criminal cases. Do jurors racially stereotype defendants? Do jurors know that what to do about improper conduct in the jury room? And how is the internet affects jury trial? In this video, we will unravel the doubt and you stay tuned. Thank you.
So the scene you saw before this is not something that's uncommon in the jury system, and it's not something that is rarely heard of when it comes to juries and the English legal system. In the book The Burmese Days, George Orwell stated that all that there has to be is a black face, and thus suspicion becomes proof. Given this, let's talk about the current situation involving juries, and let's talk about racism and how it affects decisions, and also some recommendations we can have for the future. So the first thing we have to note is that when it comes to racism in the 21st century, it is no longer the picketing or the KKK style politics of the 60s. Nobody is outwardly racist anymore because of the political repercussions that come with it. Rather, the racism in the 21st century is more insidious in nature. They don't directly discriminate against you, but they say things that potentially impact you. Maybe it's their behavior around you, how they start to maybe hold on to their valuable possessions because they think you're going to rob them, or maybe it's just in the way that people ignore you. Why is this particular segment of analysis important? It is important because racism is incredibly difficult to quantify and it's incredibly difficult to substantiate. You cannot substantiate a claim that made you feel uncomfortable. You can substantiate someone saying something racist. But given that this is no longer how racism works, that is why the legal system finds it difficult to catch up with the current circumstances that people are living in. So, based on the common law, there are two types of racism and two types of discrimination that exist. The first is actual discrimination. So, what is actual discrimination? Actual discrimination is just, well, actual discrimination. It is you maybe saying a statement that is directly offensive to a person, maybe making a reference to their skin color and thus suggesting that they are guilty. The second, and the more subliminal, is apparent discrimination. These are the more insidious versions of it. So this is maybe the jury just acting up in a more uncomfortable manner around you. Maybe it's them giving you a certain side eye. Things that are difficult to quantify but do exist in the legal realm. So given that analysis, let's talk about some tests that have been applied to juries and when we can use it to ascertain if there is racism or not. The first test was established in the case of Regina v. Goh, which happened in 1993. So this was a case that established that the basis to deciding if discrimination and racism has happened in a jury is if a reasonable man would consider bias in this case to be a real danger. However, this wasn't exactly great because the reasonable man could be the racist man, right? So the adjusted version of this test came about in Porter and McGill, which happened in 2001. In this case, two things were established. First, all English courts must align themselves with the ECHR case law, which is to suggest that the court must take into account all considerations before deciding if there is a basis to racism existing in a case. This can look like the type of community the trial is happening in. This can look like maybe you judging and suggesting maybe the people on the jury have a certain characteristic, maybe they are of a certain race, and all these things need to be taken into consideration before launching an appeal against them. So let's talk about the process of juries and how it plays into racism in the United Kingdom. So juries are selected randomly, and there is a problem with this. Even though it may seem fair, the problem is that more often than not, these juries don't represent the ethnic makeup of the areas that they're in, and they also don't represent the people who are being on trial. So you may literally have an Asian individual being tried by a jury of all white individuals, people that cannot sympathize with your cause, people that don't know of your culture, and people that also may have assumptions of your culture. That's one reason as to how it can be problematic. Now, people may suggest you can challenge juries. I mean, under the Juries Act of 1974, you can launch an appeal against a jury and you can get them kicked off if they act discriminatory. This is true, but we must look at the context of when this appeal and challenge can happen. You must first have cause to substantiate the challenge, which means there has to be a prima facie of evidence available that suggests that racism is available. That is very difficult to get because no jury is going to directly display that they are racist. Now, let's talk about the current context as well. According to a report by the Ministry of Justice, a young black individual is 9 times more likely to be sentenced to a crime as compared to a white peer of their age. Secondly, this is likewise in magistrate courts where black, Asian and Middle Eastern women are 24% more likely to be convicted of a crime compared to their white individuals. A very prominent example of a case where individuals were found to be biased was in the case of Regina and Mirza, which happened in 2004. This was a case that suggested that a jury found that the defendant was being dishonest because they were hiding behind an interpreter. The interpreter was interpreting the Arabic language. The question we would ask is, would they have asked that same question if it was French or a European language that we see as important or valuable as compared to Arabic, which we have associated with terrorism or acts of terror that has been conducted by groups like ISIS? I think all of this suggests that there is elements of racism present within the jury and that it is a problem today given the statistics of how individuals are disproportionately sentenced. So given that, what can we do to move forward? I think juries should be reasonable and they should represent the people that they are trying. And I think this is very reasonable and is something that we have done. So for instance, in the case of R.N. Litchfield, the maritime accident which involved 14 people dying was moved away to a different location in Exeter because the feelings and the emotions surrounding this case was so high in this place and in the area of Cornwall. The reason as to why it could not be held there was because the jury could not come to an unbiased decision. If we are willing to make exceptions there, surely we can make exceptions for race. For those reasons, the jury is problematic and we should probably reform it.
Hey, what are you doing?
I'm thinking of updating my Facebook about this trial.
You guys do realize that's bad, right?
Why is that?
I'll explain more once we're in the jury room. So guys, before I go any further, I have to explain the concept of sub judice and the law of sub judice contempt. Sub judice basically means that the matters of a case are under judicial consideration and therefore prohibited from discussing publicly. As for the law of sub judice contempt, it means that the courts are allowed to punish those who have specifically published material that have specifically biased against the administration of justice in a court case. It affects the jury's minds, for example, and this can result in issuing non-publication orders to publishers that have published or might publish materials that have specifically biased against the court or the administration of justice. But these traditional methods are not as effective when applied to the internet or social media in general.
Why wouldn't these methods work in regards to social media?
Well, I'll be targeting social media specifically, as social media is basically a group of internet-based applications connected through the World Wide Web that allows for the creation and exchange of user-generated content, i.e. you and I. It allows and empowers anyone to be a publisher regardless of their professional background, and they are not properly or fact-checked by, let's say, editors or sub-editors or even lawyers that the traditional print media is accustomed to hiring. As such, most publishers on the internet, most publishers on the internet are unaware of the idea of sub judice contempt, and the fear of it does not stop them from simply posting whatever they want, which may actually bias people against trial proceedings. Accordingly, it is also much more difficult to issue non-publication orders to them, as there is no specific publisher, as everyone on the internet is technically a publisher for their Twitter feeds or Instagram posts, and as such, the law of sub judice contempt and issues of non-publication orders are not as effective.
How does this affect the jury system?
Well, for the UK, our Law Commission has found that at least 18 cases from the year 2005 has been seen to be affected by juror misconduct due to internet usage or social media usage. This occurs when the jurors have used social media to communicate with the parties involved, such as in the case of Attorney General against Frail. Frail was a person on the jury with a trial concerning a drug user. And Frail used her Facebook Messenger to communicate with the accused. As such, she was found to be guilty of court misconduct and jailed for 8 months. The problem arises when people use social media like Facebook to communicate with accused persons in the trial, as they may form connections or bonds with them as unwanted, and as such, they would reach conclusions or judgments that is biased or not completely fair in the name of justice due to their connection formed. Another usage of social media that is negative is when jurors use social media to ask for opinions or judgments regarding verdicts made in cases. There was a UK juror in a case of child abduction and sexual assault who posted on her public Facebook poll requesting her friends and family and stating that she does not know what to decide and asking help from them. This is a problem as her friends and family are not actually a part of the trial. Only the person is, and only she can make the full judgment. So tainting her judgment with opinions from outside sources in Facebook would not make for a very fair judgment. And finally, jurors using internet to seek for information outside of the facts of the case. This happened in the case of the Attorney General against Dallas. A juror used the internet to research for a word, the meaning of grievous, as well as searching for past allegations of rape concerning the accused in the trial and sharing it with her other jurors. This is a problem as using the internet to seek for information outside of the current case, i.e. looking for past allegations and all that, affects the current state of mind in the case, and the judgments and conclusions made would be tainted or biased by previous allegations, and is not strictly speaking fair as is not pertaining to the current case of the matter. As such, social media and internet access has this effect of negative affecting juries' decision-making skills and fairness.
So what do you suggest?
So what I'm trying to say is that the internet and the social media is an ever-present part of our lives, and as a matter of practical reality, will be a part of our lives moving forward. I'm just not so sure on how to deal with the negative effects of social media with regards to jury trials. What do you think?
Well, I can try answering that question. But first, let me talk about how jury misconduct affects the fairness of the trial.
Be my guest.
Okay, let's begin, shall we? Okay, first of all, jury misconduct comes in many forms. Okay, for instance, eating or drinking in court, like in the case of Hughes v. Budd, or such as when juries decided to decide a verdict through lots, like in the case of Hale v. Cove, or when a jury declines to participate in a deliberation, like in the case of Scott 1997. However, the most commonly referred jury misconduct is that of how juries go through their trial with outside knowledge. In order to combat this problem, the courts have decided to take a few preventive steps. The first is that when a court takes a jury in for duty, they give the jury a leaflet called Your and Your Jury Service, which details upon the role of the jury, as well as what they shouldn't and should do in court. The court also later makes the jury sit and watch a 30-minute long video presentation on the do's and don'ts, as well as elaborate more upon the role of the jury. In fact, some HM and tribunal courts even place posters all around in order to remind the juries upon the rules that they should follow. However, there's only a certain extent that the courts can go to. After all, there's even a limit as to what the court can and cannot do. For instance, when it comes to jury deliberations, the courts are unable to intervene or even to listen in as to what is happening in the jury room. In this matter, it is up to the juries themselves to regulate whatever happens in the room and to prevent any misconduct from happening among their fellow jurors. This is important as this will ensure a fair trial and make sure that there is no biased verdict that occurs during the case. This is reinforced by the Juries Act 1974, which states that it's an offense to disclose anything that happens during a jury deliberation. There's two exceptions to this rule. The first is that once a verdict is reached, the jury can tell whatever that happened during a deliberation. Now, what I'm trying to say here is, how can a jury prevent misconduct from happening among their fellow jurors? The jury misconduct rule doesn't even allow them to disclose whatever happens during deliberation. That means whatever that the other jurors did, misconduct, sharing information, browsing the internet and telling them and influencing them, manipulating them on why they should decide against this verdict, they can't even disclose to the courts or report it thanks to the Juries Act 1974. However, the exceptions allowed them a leeway in order to ensure the fairness of the trial. After the verdict is given, a jury can go to a judge and report if there's any misconduct that occurs. The judge can then take action. However, this wouldn't be possible unless there are extenuating circumstances. That's when the second exception applies. In this exception, if a jury has a reasonable explanation as to why they believe a misconduct has occurred, they can immediately go to the judge even though the verdict is not given. The same thing is also true if the juries have grounds to accuse the other juror for any misconduct. Hence, in conclusion, when it comes to it, thanks to the jury secrecy rule, it is up to the jurors themselves to prevent any misconduct from occurring among their fellow jurors. This is important in order to ensure the fairness of the trial and the judiciary system as a whole.
Hi, welcome to our conclusion of how fair is the jury decision-making process in criminal trials in the English legal system.
So we evaluated this fairness on a couple of levels. The first level was on the element of the level of racism. So we've come to the conclusion that unfortunately fairness is not a guarantee when it comes to jury trials, simply because the jury is part of the average reasonable person and they tend to bring their subconscious biases into trials. The way they see people and the way they have perceptions of certain races or cultures impacts the way they dish out decisions and ultimately affects the way they decide on punishment as well.
We've also looked at factors such as internet usage and social media, specifically how such factors have allowed jurors to find information outside of the court or talk about cases that they're not supposed to talk about, and how this has negatively affected their decision-making process in the name of finding a fair verdict.
We've also taken a look at how juror misconduct can lead to an unfair verdict to a trial and what steps can both the court and the jurors themselves take in order to prevent this from happening.
Therefore, in a nutshell, it is definitely difficult for the jury system to be 100% fair due to the factors mentioned above: racism stereotype, social media influences, and the general juror improper conduct. In order for the jury system to be fair, prompt action should be taken by the English legal system to reduce the negative effect of the above factors. The jury system must be fair, effective, and efficient. Thank you.
Thank you.